Good evening and welcome back to KTN Prime. We are glad you are watching. As promised before we went on break, we just heard from the retired Chief Justice David Maraga, the second Chief Justice of Kenya under the 2010 Constitution and the 14th Chief Justice of the Republic. He retired just 2 days ago. We saw that ceremony at the Supreme Court, and he goes out saying he believes in terms of judicial transformation, which he had continued with that program after his predecessor, that's Mutunga, that he has managed in terms of technology to improve in that front for the judiciary being at the helm for the last 4 years, and also expansion in access of justice by building more courts, and he says ease of backlog as well. Those are the things he's described as his legacy in that interview, and of course so much more if you were watching. I want now to bring Grand Mullah, that's his nickname, his official name, Ahmednasir Abdullahi, his senior counsel. We also have with us Charles Kanjama, an advocate of the High Court. Gentlemen, thank you for making time for us this evening. So if you just heard what I mentioned then while following the interview, what do you make of the CJ's description, now retired, description of his legacy, what he's leaving behind after serving 4 years at the helm? I'll begin with you, Charles.
Sophia, first of all, let me say that the Chief Justice can hold his head high. He served under difficult conditions. His tenure was not perfect, but he did accomplish, as he said, several things. The question of technology, I can attest to that. For a long time, I was an observer at close quarters, representing lawyers in Nairobi and working as stakeholders, the Law Society of Kenya with the Judiciary, in the process of digitization. And it is a process that has had many false starts over more than 10 years, I think almost 20. And definitely we faced several teething challenges, and COVID-19 pandemic pushed us along pretty fast. But we must give it to the judiciary for rising to the challenge in difficult circumstances. We are still facing challenges as lawyers, and I think Chief Justice Maraga took a keen interest in ensuring that the technology of the judiciary would improve. It's also true, as he said, that he made dealing with the case backlog one of his signature focus areas from early on in his tenure as Chief Justice, and he did make certain strides, although we feel that he faced several challenges and the institution because of the tiff or the disagreement with the executive that resulted in reduction of funds, failure to appoint certain judges, and slowed down the timetable of the Judicial Service Commission to appoint 200 magistrates, and a few other factors that also contributed to the case backlog, including a bit of a slow pace in implementing an effective and comprehensive judicial performance tracking system, which started being implemented but not completely comprehensive. And on the third issue that the Chief Justice mentioned regarding, of course, access to justice, infrastructure in different courts in different counties, I think Kenyans also the effort he put. We know that many of these projects were funded by the World Bank. Some of them even began in the tenure of his predecessor, Chief Justice Willie Mutunga. But we must give hats off to him for seeing the projects to completion, for putting focus. There are also criticisms about procurement issues, sometimes even accusations of corruption in terms of some of the infrastructure projects. But this happens in other projects as well in Kenya. And I think the Chief Justice went out of his way to ensure the success of this. The Chief Justice spoke briefly about his judging, especially in the case involving the presidential election petition, where he is celebrated together with the Supreme Court judges for what they did in deciding, because, of course, when judges decide, they may not necessarily be right. They are allowed to make good faith decisions which may be wrong. And the remedy in the case of other court levels is to appeal, but in the case of the Supreme Court, we say that the Supreme Court is right because it is final.
All right, and we'll talk more about that.
It is not final because it is right.
We'll talk more about that presidential election nullification of 2017. Ahmednasir Abdullahi, your thoughts on the CJ's assessment of his performance. Do you agree?
No, I completely disagree. I think Justice Maragas' tenure was complete failure. He has achieved very little. He has exaggerated his achievements. He takes credit where none can be attributed to him. But if you look at the three substantive issues he has achieved, he said he has cleared backlog. Which backlog has he cleared? We practice in this court, and cases take 10, 15 years to finish. If you look in the Supreme Court, which has maybe 100 cases at most, it has a huge backlog. When a case is had in the Supreme Court, during Mutunga's time, when you finish the case, judgment date, you are given a judgment date of maximum 3 months. Nowadays, when Maraga came, you are given judgment on notice. With me, it takes between 6 to 9 months at times for the judgment of the Supreme Court to be delivered. So the backlog has gotten worse during his tenure. And then he talks of infrastructure. There is not one building he has built during his time. All the infrastructure of the judiciary were done during Mutunga's time. I was a member of the JAC when we initiated those projects. William Mutunga negotiated a 10 billion shilling with the World Bank. And he has been opening projects, some of them incomplete, just to say that he has completed, that he has opened some buildings. Then when you come to technology, even my learned friend Charles is talking of technology in the judiciary. What technology? There is absolutely nothing technological about the Kenyan judiciary. Okay, when COVID started, I mean, the courts, there was this Zoom court sessions.
Yeah, isn't that technology?
Well. I mean, if I will give...
Isn't that
but
technology?
I'm saying this is something COVID. When it is, but it is something peculiar to the COVID crisis. And it's only some courts that have done well, especially the Court of Appeal.
But it means it's there and it can be done.
Let me finish first.
Okay, go ahead.
There is zero technological advances in the Kenyan judiciary. The system is still shorthand. There is nothing in court recordings. If you go to any high court in Kenya, there are only 3 courts or 4 courts that are doing some test trials. But I don't deny, because of COVID, we had some hearings on Zoom. But there is nothing. There is no advancement in technology. And I think the Chief Justice, there is a question you have repeatedly asked and he refused to answer. What has he done on corruption during his tenure? There is not a single statement he issued during his tenure on corruption. There is not a single initiative he took to fight corruption. And I think he has completely avoided, you repeated the question, and then he was telling you about something about a court clerk stealing some money and office messengers stealing money. What has he done about the corruption in the Supreme Court, for example, or in the High Court, or in the magistrate courts? Zero, absolutely zero.
Quite a harsh indictment from Ahmednasir Abdullahi, but to the point of backlog, and instead of the judiciary address last year, he did a breakdown of just where he found the judiciary and the numbers of cases they had handled, and that they brought the backlog down to, I think, 71%, and acknowledged the challenge, of course, of COVID, which then slowed them down as an institution, but also that judges, there is a challenge of the number of judges hearing these cases. Isn't that playing into the backlog? And we have seen the president's refusal, quote unquote, to appoint these judges.
I know this thing more than many people. The backlog is still a problem. And it's not because we don't have enough judges. I know we can do better with more judges. And I understand that the government or the president has refused to appoint 40 judges. But if you look at 10 years where we were, that is 2010, we increased the number of judges by 400% in the High Court. We increased the number of judges of the Court of Appeal by 300%, although now I know they have gone down a little bit. We have increased the number of magistrates by about 600%. We have enough judges. The problem with the Kenyan judiciary is there is no accountability, there is no work ethics, there is no proper returns. The Chief Justice, to his credit, he's very good in sexing up figures. You know, every time he used to say that, oh, we have cleared backlog of 80%. I practice law up to the High Court, the Court of Appeal, and the Supreme Court. And the only court I give credit in terms of addressing backlog is the Court of Appeal. The Supreme Court has a huge backlog problem. The High Court has a huge backlog problem. The magistrate courts have a huge backlog problem. And it's not because we don't have judges. It's because of our work ethics. There is no accountability in the judiciary.
Charles Kanjama, I'm curious to hear your thoughts, because I did put to him, it was a promise he made when he was being vetted in 2016 to the JSC, that he would fight corruption cartels in the judiciary. And you heard his response to that. What is your take?
I think, being candid, the question of corruption is still a challenge in the judiciary. And I would say, giving an institutional assessment on behalf of many of my colleagues who we have discussed the question of corruption in the judiciary and who have expressed interest, there hasn't been any dramatic shift in terms of the trajectory in fighting corruption. There are various attempts that have been made to fight corruption. You see, corruption is now twofold: corruption within the country and then corruption within the judiciary. For corruption within the country, of course, there have been more magistrates assigned to deal with anti-corruption cases, and there's been a big push by the judiciary to speed up the handling of anti-corruption cases. Has that given results? Not very dramatic results, but there have been some results. On the question of corruption within the judiciary, I think we can look at it broadly in terms of complaints against judicial officers. There may be complaints of financial corruption, there may be complaints of delays, of incompetence, of one thing or the other involving judicial staff. Of course, we know there is the Ombudsman office in the judiciary that is meant to process the complaints, and this office was given to a very high level, to the Deputy Chief Justice to be in charge, because the Chief Justice felt that there needed to be high-profile engagement in dealing with corruption within the judiciary. But the perception of lawyers, at least many lawyers that I know who interact daily with the judiciary, is that there has not been any dramatic change in the trajectory over the last 4 years. Efforts have been made since 2010 with the vetting of judges and magistrates, with performance measures being implemented, but there are concerns that corruption is slowly creeping back. And when I say this, it is very important that I clarify that the vast majority of judges and magistrates are hardworking individuals with integrity and without complaints. But we'll always have a few rotten apples in any basket of apples. And the question is, how do we deal with these rotten apples? How do we deal with complaints against judicial officers? There has been a feeling that we are not doing enough.
You're not doing enough. Ahmednasir, let me come to you. We also touched on the historical 2017 nullification of the presidential election, and you participated in those proceedings as counsel for one of the parties. Why are you surprised to hear Maraga admit that, in fact, there was an attempt to assuage him or perhaps change the decision that had been made, or at least a call was placed to him a day before they delivered judgment to annul the election?
You have to understand Maraga's history before you ask me to pass judgment on that case. If you look at the 5 years he was Chief Justice, you can't remember, or not one lawyer can recall a serious case he has decided or a profound decision he has made in terms of jurisprudence. But what we can remember for him are two things. One, that decision of the Supreme Court, and secondly, that advice he gave to the president to disband the court, the parliament. So because Maraga could not, to be fair to him, he was not a great jurist from day one, or he was not, a famous lawyer from day one. But he has filled those gaps in terms of his history by making decisions that are political. So the case of 2017, was a political case. I was involved in that case. The difference between the president and Raila was 1.5 million votes. There is no way on earth that a competent, impartial court will have nullified that election. But Maraga was more of a drama man, he was a queen. He was more of a drama. So he wanted the world to remember him, not because he can propound a sound jurisprudence even on that case, but because of the effect, the political ramification that case created. So he wants to be remembered from a political point of view. And his second decision on Parliament should also be seen in that light. Leave alone this thing of people calling in by phone. Those are crap.
Ahmednasir, to be fair, let's watch our language kindly. In that decision to annul the election, it wasn't just Maraga. There were other judges.
What language?
The word you just used at the last part. I'm not going to repeat it. But it was not just Maraga who annulled the election. There were other judges who... It was a decision of the majority judges at the Supreme Court, isn't it?
Yes, I'm telling you for the record that was a political decision by the court. It was nothing legal about it. Get it?
All right. Charles Kanjama, your thoughts?
Okay, let me start by saying that the Supreme Court, as an apex court in different countries around the world, has to balance between judicial decision-making, which is really what should guide them, and sometimes a bit of a political angle of the effect of their decisions. As lawyers who are purists in the law, we hope that the highest court in the land will decide cases on the basis of the facts and the law, and not take into account extraneous considerations, which may be political, human considerations, what will be the impact of this decision or the other. Without focusing wholly on the presidential election petition decision, which has been discussed extensively in various fora, I think there is a concern among several watchers of the jurisprudence of the Supreme Court that there have been a number of cases that they have decided. Of course, they've decided numerous cases, but there have been a number of cases that they've decided where the politics seems to have been the prevailing factor in the ultimate decision that was reached. And there is a feeling that the Supreme Court needs to go back to its jurisprudential roots. There is a feeling that there is a bit of inconsistency in certain decisions that is emerging, maybe for political reasons, that there is a greater reliance on technicalities in some decisions of the Supreme Court. I'm speaking honestly of conversations that have taken place among several lawyers, including senior lawyers, are giving a very candid analysis of the current Supreme Court. Okay. And of course, there are those who feel that even the decision in the presidential election petition case of 2017 included a large dose of political consideration. For myself, what I would like to say, and it is my motto, fiat justitia ruat celum. Let justice be done, though the heavens fall. And I think there are times when the Supreme Court may have departed, either in small ways or in bigger ways, from that idea of a pure justice based on the facts and the law, and let the chips fall where they may.
And so Honorable Maraga went on to say that for failure by the president to appoint the 41 judges, now 40, following the demise of one, and subsequent disobedience and disregard of court orders, In other jurisdictions, the president would have been impeached. And when pressed on whether then this president should be impeached and held accountable by Parliament, he said, yes, for sure. Do you agree, Ahmednasir?
I think there are 2 points, and we need to make a distinction. One, I think there's a general consensus that the president is absolutely wrong in his refusal to appoint the judges, and there's no excuse on that. And I think everybody has condemned him on that. And you know, I'm on the same page with people who have expressed their views. But in terms of disregarding court orders, which have become norm, and I practice law, and I think Charles will agree with me. Every time when lawyers come to court and say that this order has been disobeyed, the consequence of disobeying a court order is to jail the contemnor, no matter how powerful he is, whether he's a minister of internal security or a minister in charge of immigration or a minister in charge. It is the courts in Kenya that refuse to punish the contemnor. And the Chief Justice does not or refuse to take cognizance of that. As lawyers, as litigants, the only way to address disobedience of court orders is to put in jail. That's what they do in civilized world. But the courts in Kenya don't have the backbone to do that. And that is why disobedience of court orders is a big problem. The other issue, I think I've explained that the president has no excuse. He is in complete breach of the law. And I think when we have a new Chief Justice, I'm confident that in 2 weeks or 3 weeks after that, those 40 judges will be appointed.
But shouldn't there be, as the Maraga was talking about, impeachment proceedings, it shouldn't depend on who the Chief Justice is. It shouldn't be left to the whims of a president. If the law stipulates, as it does on the matter of appointment of judges, why should it be saying now that we're going to wait for another Chief Justice who the president may find more friendly? So what consequences are there for the president?
It's for Parliament. The only organ that can impeach the president is Parliament.
Yeah. All right, I hear you. The only organ that can impeach the president is Parliament. But then again, coming back to you, Kanjama, in the political landscape we're in, that is the most unlikely thing to happen, at least at this point.
Yes, it may be so, but I would like to say that the judiciary has to find creative ways of dealing with contempt of court orders. And I would like to agree, a bit reluctantly, but agree nonetheless with Counsel Ahmednasir, that for those of us who practice in the courts on a daily basis, from the Magistrates' Court to the High Court, the Court of Appeal, the Supreme Court, the special courts, the tribunals, it is a cancer that is affecting the practice of law and the administration of justice, and it is growing. Wanton disobedience of court orders. And sometimes you feel, when you are representing a client who's on the suffering end of this disobedience of court orders, that if the court could be a bit more firm, if the court could be a bit more concrete, a bit more decisive, if the court could be sometimes even more creative in enforcing its own orders, it will help to diminish the kind of like widespread disrespect for court decisions. Sometimes it's a small things like money decrease. There's a judgment for money to be paid against an individual, a corporation, or even the government. The government never pays. And I heard Chief Justice Maraga actually bemoan that fact of the government failing to pay, even decrees against Kenyan citizens and other people who have judgments against the government. And then we see that the courts have also tried to improve the law, what we call the jurisprudence on contempt. They have said you no longer need to serve personally the court order so that someone can be held in contempt. You just need to show that they knew of the court order and the court will find for contempt. But in the actual cases where there is clear contempt and you go through contempt proceedings, and I've done it in a number of instances, you sense a strong reluctance when you push the case to that ultimate point of find this person, sequester their property, which means take their property, or imprison them. you tend to find a reluctance for the courts at the last step to implement their court orders. Right. And I think this has ended up rebounding against the judiciary. And that is why when court orders are made, like for the president to appoint the 40 judges, there were 41 before, one passed on, the executive doesn't fear to disregard the court orders. I personally have recommended certain solutions. There were some petitioners who went to court and they said, can the court deem these 40 judges to have been appointed? If the president has failed to do his constitutional duty, the court did not agree. There are ways in which you can deny audience to the state law office or to certain government ministries until they obey court orders. You can even authorize people, for example, to withhold taxes. You can put pressure points or pain points on the government until they comply. Even if Parliament, with its process of impeachment, fails to act, the judiciary still can act with creative ways of coming up with remedies. But there has been a deficit in this area.
And I hear you both on talking about there being more that needs to be done in regarding obedience of court orders. But actually the retired Chief Justice talked about that at the end of the day, even when these orders are issued, and it's the police that are to enforce, sometimes the matters will go and the police starts canvassing those matters all over again at the police station. So that aren't the hands of the judiciary then tied, Ahmednasir, to the extent of then how these are treated? Because we saw when certain contempt orders or appearance were issued to CS Interior and the same were disregarded. So what does the judiciary do? Issue another order?
I think I mean, the court order is the norm in this country, and it's very unfortunate. But it's how do we address that disobedience? For example, I mean, this famous case of the courts have given orders time and again that you will be back. The government has disobeyed time so many times, but they should be to that process. You ended that process is for the court to say that, you know, X has disobeyed my court order, I'm jailing him 6 months. I mean, I disagree with my learned friend about innovative ways or, you know, stylish way of enforcing court orders. I mean, that is escapism. You know, you are making excuses for people who disobey court orders. I mean, when someone disobeys a court order, you must punish. If you don't want to punish or if you are scared of punishing, and our courts are scared, then don't give the order in the first place, because it destroys, you know, the integrity of the court. It destroys, you know, the power of the court. The Kenyan courts should not give the order in the first place if they can't enforce the order.
Yes, go ahead. Let's talk about financial autonomy, judicial financial autonomy. That has been an issue. Again, Maraga seeing it as the revisit threat from the president, and that they've continued seeing reduction of budget. This has immensely affected their services. So back to you, Ahmednasir, before I go to Kanjama. Because there is a judiciary fund, it's in place, it's operational, but how do we depoliticize that so that it's ring-fenced as opposed to being left to the whims of political class? All right.
Were made, and Willie Mutunga was the Chief Justice. And it depends on, you know, the Chief Justice, it depends on his rapport, it depends on his finesse, you know, it depends on how he interacts with people, it depends on so many things. And Willie, when we joined when he became Chief Justice, I think in 2011, somewhere there, the budget of the judiciary was, I think, 3 billion. He went to President Kibaki, he had a meeting with Kibaki and Madaura. He said, this is not tenable. He was asking, how much do you want? He said, I want this. Kibaki gave him, and every year since then, the budget of the judiciary was going up and up and up. When I left, I think it was about 17 billion. I mean, when Maraga came, I mean, I don't know, everything went, things went south, I mean, the judiciary and government started.
Ahmednasir, I remember the president speaking during the inauguration of Maraga, and he made a case for how in his administration, he continued to increase the budget, gave a case for how low it was and what he had done to that extent. So it was not to Maraga's fault or because of Maraga's entry at the time that things were still going well in funding. And then the ruling happened to annul. And then
the point I'm making is the point I'm making is that if you have a good rapport without compromising your independence, the judiciary can get what it wants from government, and that is what Willy Mutunga did with the Kibaki government, and they were given. Of course, I know when Uhuru came, and Willy was still CJ, he had problems, and I think they started cutting the budget, although it became a little bit more drastic during Maraga's time. But what we are facing is just the politics of, the interaction between the executive and the legislature. But I agree with the former CJ that it's very important for the judiciary to have autonomy on its finance. It's very important. If you want to have a world-class judiciary, you must finance it. You can't finance the Kenyan judiciary with a budget of 13, 14 billion. It's not tenable. You must give it adequate resources. You must employ more judges. You must put more technology. You must have more, all these things. So, the government is fighting the judiciary, but what they don't know is that, they are compromising the quality of justice the Kenyan public is getting. If you want the money in Mandera to have a high court, you must put money there. If you want the judgments to be, if you want the cases to be heard in 2 years, you must finance that. So finance is important, and it's very unfortunate that this government has deprived the judiciary of the money it so badly requires.
Charles Kanjama, your thoughts on having good rapport with the executive, legislature to ensure you're well funded as a judicial institution?
The Supreme Court itself, in more than one decision that it has issued, has talked about institutional committee, which is precisely your question. That is a general good relationship between the three arms of government. And I think that is something that is appropriate. Chief Justice Maraga insisted that committee doesn't mean that the judiciary is not independent or doesn't rule occasionally against government when it is required to do so, but it means there needs to be a good rapport. Definitely, in the last few years, that good rapport deteriorated significantly, and this can be attributed to the revisit moment and what happened thereafter, so the last 3 years. But definitely to build rapport is not just a question of the institution, is also the individuals and the ability to engage with one another. And it is quite unfortunate that in the last 3 years, that engagement was not very successful. And it was not for want of trying, I think, on the part of Chief Justice Maraga. He did try on several occasions to make it clear that decisions of the judiciary doesn't mean they have anything personal. It is just the decision they've reached according to their good faith analysis of the situation. Whether it is right or wrong, it is an authority that is given to them by the Constitution. And so one of the things that the judiciary was asking for, I'm aware, is for a judiciary fund with a minimum allocation. In fact, they were asking for 2% of the ordinary revenue that the government has, at least 1.5%. And it has been a major challenge because the Ministry of Finance seems not to understand some of the needs of the judiciary. You see, when you put up a road, when you put up a building or a bridge, everyone sees the bridge, it's physical. But when you fund the judiciary, unless it is for infrastructure, no one can see the physical thing because it's a service that is being given. And so there is a challenge even for the Ministry of Finance or Treasury lately to really appreciate and understand the way the judiciary operates. And there have been engagements. I know the Law Society did agree to assist the judiciary in engaging Parliament, in engaging the executive. But we've not been very successful. The Justice and Legal Affairs Committee of Parliament has tried to do its bit. It's not succeeded so far.
All right, gentlemen, as we wind up, we have about just 2-3 minutes to go. Towards the end of our interview with the retired Chief Justice, we talked about how judicial officers, whether there should be a mechanism when they're facing integrity concerns. And he at first said they should face due process, be treated like everybody else. The only thing we've seen in the public service, for instance, if it's CSS, some instances stepping aside for governors, different rulings. We've seen some facing cases, being told do not access office, but some continue with work, yet they're facing charges. And so he leaves in the judiciary at the helm, acting CJ, who's also the Deputy Chief Justice, who is facing integrity questions. I wonder what your thoughts are, Ahmednasir, on that, because the argument is what is good, as we said in the interview, for the goose is good for the gander, and that's what some critics have argued is a double standard.
No. On this, I agree with the former Chief Justice. I mean, the judiciary is a special or a unique institution. And, I mean, prosecution in Kenya or investigation and prosecution in Kenya are very political. If the government doesn't like a judge, there is nothing that stops, the director of CID, Kinoti, to start a frivolous investigation, come to court and say that I want to arrest the Chief Justice, or I want to arrest the Chief Justice, or a judge of appeal, or or Supreme Court. So the judiciary has its own unique mechanism. There's a Judicial Service Commission. You take the complaint there. They do the investigation. I mean, I've been there. It is a very effective process. Once you do the investigation, if it is, frivolous, they dismiss it. If it is substantive, they recommend it to the president to appoint a tribunal. And that's the best way to insulate the judiciary, from this reckless intervention of the executive that's so common. So I agree with them. I mean, I know the Deputy Chief Justice has some allegations that are facing her, but I think the judiciary has taken the proper procedure of taking her through the Judicial Service Commission. When a judge is going through the Judicial Service Commission, it is an internal process. I mean, there's no need for her to step aside or to leave. But we need to make a distinction, from, if you are an employee in the executive or in the civil service, those ones you step aside because there's a specific law that addresses that. On the judiciary, there's a specific law that gives judges security of tenure. So we need to make this distinction. Of course, I am aware that some governors were told to step aside or cannot access office. I've expressed my view on those decisions. I think those are decisions that have been passed by certain courts to please the executive. I think they are bad in law. And if we had a proper Supreme Court, those decisions will have been overturned. But everybody is scared of the government nowadays, don't they?
Are you scared? To Charles Kanjama, your thoughts on the same question?
Okay, I will say the first point is that I agree with the idea that a judge cannot just step down merely because there are allegations against them. That would be one of the ways to interfere with the independence of the judiciary. However, I like saying that there are two faces to the coin of judicial independence, and the other face is judicial accountability. And I have two reservations with the scenario you have painted. The first is that it would not be seemly, it would not be appropriate if there is an appearance of when judges are subjected to complaints against them, whether the complaints have been taken to the Judicial Service Commission or any other forum that constitutionally is authorized to investigate or to pursue the complaints, those complaints are slow-walked or are delayed or are not dealt with sufficient dispatch. In fact, it is precisely because of the high integrity requirements for the judiciary that those complaints have to be dealt with fast enough. And I must say, as an observer, that I have been concerned in several instances where I felt there were unexplainable delays or slow walking, and sometimes the slow walking unfortunately included brother or sister judges making decisions that slowed down cases or complaints against their fellow judges. I think there is need for self-examination or examination of conscience by the judiciary on how they deal with cases that involve their brother and sister judges and magistrates. That's the first point. And the second reservation that I have is that I think it should not be very smooth for us to just casually talk of two sets of standards, one for the judiciary because of their high office, and one that applies to everyone else. I have been on record from way back in 2010 during the time of the International Criminal Court and later to say that different standards of justice or having selectivity in the way you apply justice, that there's one category of people who face special considerations for justice. You know, justice is meant to be blind. In other words, it doesn't matter your stature or your position. The standard should be the same. So if we say that there'll be a different standard for the judiciary, of course they have independence and security of tenure, but that governors will not have that standard, or other people with security of tenure will not have that standard, then there is a problem. And I think it is important for us to ask the judiciary to reflect on their own jurisprudence, because they have jurisprudence on Chapter 6 regarding state officers and who are charged with cases of corruption.
Right.
Judges and magistrates are also state officers. So if that jurisprudence only applies to some state officers and not others, there's a problem with that jurisprudence. Okay. And I think there is need to refine the decision-making on these issues of corruption and state officers.
All right, gentlemen, our time is up. Many thanks for being with us tonight here on KTN Prime, taking that conversation forward. Retirement of David Kenani Maraga as Kenya's second Chief Justice under the Constitution of Kenya 2010. Indeed, you can catch more details of that interview earlier, what more the CJ had to say in tomorrow's Standard newspaper. That has been Charles Kanjama, advocate of the High Court, as well as Ahmednasir Abdullahi, senior counsel, with us, sharing their thoughts on the CJ's tenure and what he